Bill 60 just passed in Ontario, and instantly the reaction splits into two completely different words. Landlords are saying, finally, something that protects us. Tenant advocates are saying this will push vulnerable people into homelessness. In this video, I'm cutting through all the noise. I'm breaking down exactly what Bill 60 actually changes, who gains, who loses, and what this means for landlords, tenants, and investors in 2026. My name is Navjot. I work with landlords, investors, and families across Ontario. And I actually read legislation so you don't have to. Quick disclaimer, this video is information purpose only, not legal advice. If you are in a dispute, please speak with your paralegal or lawyer. All right, let's get into it. Bill 60 is a large bill, but one section, Schedule 12, updates the Residential Tenancy Act, and it affects 5 major areas. This is emotional one. Under the old rules, if a landlord wanted the unit for themselves, their spouse, or their child, they usually had to pay the tenant 1 month's rent as compensation. Bill 60 removes that compensation in many cases. Here's the new rule, simplified. You give 120 days notice. The termination date is at the end of the rental period or the lease. If you follow that, you don't owe the 1 month compensation. From the landlord's perspective, it's my property. If I follow the rules, why am I paying to move into my own home? From the tenant's perspective, rents are way higher now. Losing my home and losing that cushion hits hard. Before Bill 60, the termination date on a non-payment notice was usually 14 days. Bill 60 cuts that to 7 days. For landlords, you can start the process twice as fast. For tenants, you have half the time to fix the problem. And the law treats can't pay and won't pay the exact same way. Before Bill 60, even if rent was owed, tenants could still raise issues at hearing. Maintenance, repairs, right violations. Bill 60 still allows that, but now there is a condition. To raise those issues at the hearing, the tenant must pay 50% of the upfront and pay it before the hearing, within the timelines. For a tenant who had the money but didn't pay, this forces accountability. For a tenant already struggling, finding 50% upfront is almost impossible. So on paper, tenants' right stays the same, but in practice, fewer tenants will be able to use them. Persistent late payment has always existed. If you repeatedly pay late, you can be evicted, even if you eventually catch up. Bill 60 doesn't change the concept, but it changes who defines it. The definition moves out of the Act and into the regulations, and matters because regulations can be changed quickly without passing a new bill. So if a future government decides that a few late payments a year counts as a persistent late payment, that could actually become the new standard instantly. Previously, you had 30 days to request a review of an LTB decision. Bill 60 cuts that to 15 days. For someone with help, 15 days is fine. For someone juggling work, kids, language, or health challenges, 15 days disappears fast. Miss that window and the decision becomes final. People keep saying this only affects bad tenants. And yes, faster enforcement absolutely helps deal with the tenants who refuse to pay or damage the unit or cause serious problems. But here's the issue. The law is a blunt tool. It doesn't separate people into clear categories. It treats a good tenant having a bad month, a low-income tenant struggling, a newcomer still learning the system, and a truly bad faith tenant all the same. So yes, this will make dealing with bad tenants easy, but it also increases the risk for vulnerable tenants who fall behind due to life events they cannot control. There's a debate. If evictions are faster, will landlords be less strict with screening? Maybe a little. But screening exists because turnover is expensive, vacancies are expensive, repair costs money, and conflict drains time and energy. Bill 60 reduces downside risk, but it doesn't change the fundamental of the business. Some landlords may take a chance on borderline applicants, but overall, strict screening isn't going anywhere. If you're a landlord or investor, here's what matters. Number one, get your paperwork perfect. The new rules reward precision. Number two, don't get reckless. Faster evictions don't make tenants disposable. Turnover still kills profitability. Number three, protect your reputation. Being known as fair and firm is a major competitive advantage. If you are a tenant, act fast. Deadlines are shorter now. Know your numbers. If your budget is tight, try building a small buffer. Document everything: repairs, requests, communication. Keep it all in writing. Bill 60 isn't about good or evil. It's about shifting power and tightening timelines in Ontario's rental system. It clearly benefits landlord and investor, and it clearly makes things harder for tenants living close to edge. If you found this breakdown helpful, hit like, subscribe, and drop a comment. Are you a landlord or a tenant? And how do you feel about Bill 60? In my next video, I'll break down how these changes impact cash flow projections and investor risk heading into 2026.